Jury cases. Hey, when it involves a civil case, a money award, when the jury comes back and they vote in favor of a money award, that's the end of the case, it's all over and done with? Or is it? Well, it takes us to this week's case. It involves a medical malpractice case, one of the most massive verdicts in a medical malpractice case ever, $606 million. But guess what? When the case was all over and done with, only $1 million was paid. Only $1 million was paid. Judge did not order a new trial. The case was not appealed, and the judge did not reduce the verdict. But the party who was found to be responsible paid only $1 million, even though the jury awarded $606 million. So how does that happen? Well, in this instance, something took place that a lot of people aren't aware of, and that is the two parties. The person who was hurt, the plaintiff, and the defendants, the defendant doctors, had entered into an agreement through their attorneys during the trial, and they agreed, because obviously the trial was going very well, that in the event the jury came away and voted in favor of the plaintiff, that the maximum amount that would be awarded would be $1 million. And the defendants agreed to pay that $1 million even if the jury came in with an award of $700,000 or even $2 or $200 million. In this instance, they came in with the award of $606 million, and they only paid to the plaintiff $1 million. But they also had agreed that in the event the verdict came back in favor of the defendants, the doctors who were being sued, that they would also still pay $200,000. Well, that kind of an agreement was reached because obviously the case was going very well. But what this demonstrates and what this shows is that sometimes when a jury trial takes place, the parties have agreed, both the plaintiff and the defendant have agreed to a high-low bracket, meaning that the most that's going to be paid is agreed to before the jury comes back with its award, and the least that is going to be paid has also been agreed to. Of course, the problem with these agreements is trying to figure out what that high and what that low should be. So why would these parties do that? Why would they do this? Well, the big reason they do it is because jury verdicts are very uncertain, extremely uncertain. I think most people think that if a case is tried to a jury, they hear the witnesses, they see the evidence, that they're going to come away with the same verdict. Not true. Not true. Anybody who's ever tried a case realizes that you try a case before a jury today, and you try the same case a month later, same witnesses, same evidence, that you're going to get two different verdicts. That's the way it always happens. Why? Because it's the dynamics of the jury. Who is going to speak the most on that jury? Who's going to have the most influence? And that's why selection of a jury is so important. So this is why parties will many times agree either during a trial or before a trial to agree on a bracketed result, meaning that they will agree a maximum amount that will be paid and a minimum amount that will be paid. And the jury still plays a very important role because these parties couldn't figure out what the case was worth, they couldn't agree, and if it weren't for the jury actually deliberating and voting in favor of a verdict either one way or the other, that case would never be resolved. But the nice thing in that kind of an arrangement is that the parties who are involved in it know that there's going to be certainty. The case will be over and done with when that verdict comes back, and then they go to their bracketed award, either that high or that low, because there won't be any appeal, there won't be 2 years or 3 years spent going up to an appellate court. There was a lot of time and money spent in that jury trial, and they just want to have that case over and make sure it is over. Okay, we bring you this case, like we bring you cases every week, so you understand how the law really works. I'm David Allen.